Judge, good evening. We've come full circle to the end of the dais. Likewise, I don't intend to use all of my time. I do want to echo the sentiments expressed by Senator Tillis. You have conducted these hearings with extraordinary poise, strength, grace under pressure. You've had a lot of poison thrown at you, and you've responded with substance and truth, and it's shone through, not just in this room, but across the country and around the world. So I have two substantive questions regarding the First Amendment. One question, as I noted, that I wanted to address regarding war powers, and then I'll be yielding the remainder of my time to the chair and on to Senator Blackburn to close. We discussed earlier this morning, Judge, the constituent elements of the First Amendment with respect to speech, expression, and assembly. I just briefly want to touch on the free exercise of religion. My great-grandparents came to this country fleeing anti-Semitism in Eastern Europe. Many American stories, including many of the very first American stories, involve flight from religious persecution. Just briefly would ask you to touch upon the constitutional roots and significance in our system of government of the First Amendment protection of the free exercise of religion.
Thank you, Senator. As you mentioned, free exercise of religion and the Establishment Clause, which prevents the government from preferring religion over another, is foundational. It is the principle that many people originally came to this country when it was founded in order to support. It was people who fled from religious persecution and wanted to found a country in which everyone could believe what they wanted to believe and not have the government encroach on, impinge on, burden that right. And so it is a core foundational right. It's in the First Amendment, and your family story is very similar to many families who moved to this country for that reason.
Thank you, Judge Jackson. We discussed in brief earlier today the Sullivan decision, New York Times v. Sullivan, in which the court established a standard by which libel and defamation claims by public figures would be judged. And my understanding, correct me if I'm wrong, is that the standard is that false statements must be made knowingly, that the party making the false statement must know that it is false, and must make such knowingly false statements with malice. Am I correct that that's the standard in the case?
I believe it's knowingly or with reckless disregard for the truth, and that standard is termed or thought of as actual malice, yes.
Is there any generalized obligation in law that you're aware of to accurate reporting or accurate publication where there is not malice or where there is not one of the components established in the Sullivan case?
If I understand your question, I know that the standard related to the Sullivan case does pertain to public figures. And so if a public figure is not involved, there's a different standard in terms of liability for inaccurate or defamatory statements.
Thank you, Judge. And I want to note that the chairman earlier remarked upon the disruptions in the market in publishing and the dissemination of information that technology has caused in recent years. And I was just reflecting as the chairman spoke that at the time of the invention of the printing press, many of those who previously had centralized control of the production and dissemination of information recognized that it was disruptive and threatening, and that it disrupted power dynamics, and it empowered new participants in public discourse to participate. And I just want to express to you, this is not a question, but express to you my view that it is vital that we in Congress and the judiciary relentlessly defend the principles of the First Amendment and the free expression of ideas, even as new technologies emerge which disrupt these markets and present challenging new particular circumstances to the court. A very brief question on the not lighthearted but important subject of war powers. I reviewed some of the comments that prior nominees have made when asked about questions with respect to the allocation of war powers between the legislative and executive branches. And something that I've seen in some of those transcripts has been a tendency to say, well, these are disputes between the political branches, and questions about those authorities should be resolved between the political branches. I noted in the McCann opinion that you issued, you noted in that case that one of the reasons it was appropriate for the judiciary to consider the claim made by the U.S. House in that case was that where there is a dispute between the legislative and the executive, in that case, and perhaps in many cases, the judiciary is precisely the appropriate forum for the resolution of that dispute. And so it seems to me that the court and you, should you be confirmed, may very well have to entertain cases and controversies pertaining to disputes between the legislative and the executive with respect to war powers, because there is, in my opinion, unsettled law. There's some ambiguity in statute. The Constitution allocates various authorities to the two branches. So not asking you to posit a thesis on this point, but just want to ask you how you will approach such cases. I assume applying the methodology that you have laid out for us consistently throughout these hearings, where war powers may come before the court.
Thank you, Senator. In every case, I applied the methodology that I have laid out in order to ensure that I'm ruling impartially and consistent with my judicial authority. In the part of my methodology that addresses my judicial authority, one of the things that I do, as judges do, is decide whether I have jurisdiction to hear a particular issue. The McGahn case was not a war powers case. The McGahn case, I determined in that opinion, and Judge Bates had determined in the prior opinion, raised a question of law. The question essentially was whether the subpoena that had been issued by the House had to be responded to by the person who received it, or whether that person had absolute immunity and did not have to respond. That's a question of law that courts answer all the time with respect to the enforceability of subpoenas. In the war powers realm, there may be questions of law that are appropriate for courts to decide, but there may also be political questions. And so it would depend, a political question, if there was a dispute between the legislature and the executive branch over some exercise of authority that was not governed by law, but was in the discretion of either of those branches under the Constitution where they got to make determinations, something, say, for example, like the exercise of executive authority in war to move troops or do that kind of thing, that would not present a question of law that the court could decide. So it would depend on exactly what the court was being asked to do as to whether or not it had jurisdiction. And under my methodology, that would be the kind of thing that I would have to carefully examine in order to determine whether I could rule.
Thank you, Judge. Let me close with this comment. As I said, you have conducted yourself with extraordinary skill and grace throughout these proceedings. And it's in some ways a lonely place for you to sit there under the lights, facing questions, many of them substantive, some of them less so, many of them constructive, some of them mean-spirited and distracting. You've handled it all extraordinarily well. It's been a very long 2 days. I know you know this, but I just want to make sure you do, that throughout this process, and right now, there are millions and millions of people who are watching and cheering you on, right at this very moment, in homes across this country. There are millions and millions of people inspired by you and your example who are cheering you on. And not just that, there are people all over the world, who are watching these proceedings and seeing what is possible in America. After some years when there's been some doubt about what this country stands for. That's my opinion, not yours. But people all over the world are watching this and seeing what is possible in America, what is possible in the system of government that we have, what values this country stands for. And I thank you profoundly for the service you've rendered throughout your life and in this hearing. And with 7 minutes remaining, Mr. Chairman, I know you'll remain focused right through the end. I have no doubt that Senator Blackburn has some provocative questions for you. I yield the remainder of my time.